Today we are going to discuss the concept of fair investigation. We know that police conduct or state agencies conduct investigation. That investigation should be fair. Fair means as per law, as per the complaint given by the informant, as per FIR. That means in complaint, suppose we give a name of accused, that means he committed that offense, but he is influential person. Because he is influential person, police may remove his name. Police may not add in his name, though it is there in information given by the informant. Victim, informant means victim. Or though the complaint, the information is making a serious offense, they may not add that serious offense in FIR. Then, so these are some of the mistakes intentionally done by police. So that is not fair investigation. So removal of some persons, adding of some persons unnecessarily, or though information is disclosing serious offences, adding only lighter offences, all these are some of the concepts doing by police against this fair investigation. Then what is the right of victim? Then what is the right of victim? So now the Supreme Court held that getting fair investigation is fundamental right of victim. Not only, it is not only constitutional right, it is also human right. Not only constitutional right, it is also human right. So not only accused, victim also have right. Now come to the judgment of the Supreme Court. Supreme Court recently in Anantathanur Karmayus versus State of Maharashtra 2023 February judgment it is. 2023 volume 3 SCR 56. In that case it is held that fair investigation is concept of Article 14, 21 and 39A. So basing on two judgments earlier, two judgments of the same Supreme Court, in 2023 judgment, the Supreme Court held that it is the constitutional courts are having right. Constitutional courts are having power to direct re-enquiry, fresh enquiry or de novo enquiry, like that. So Supreme Court in 2023 case held that constitutional courts are having right to direct the police to conduct fresh enquiry, re-enquiry. So before that, Supreme Court is depend upon the previous judgments. What are the previous judgments? Now see, this is called, the judgment is called Dharampal versus State of Haryana and others. This is 2016 judgment, 2016-4 SEC. In this judgment, Dharampal versus, the Supreme Court held that constitutional courts, that means Supreme Court and High Courts, are envisaged with the power to order fresh, de novo or re-investigation, and as observed and held the commencement of a trial and examination of some witnesses cannot be an absolute impediment for exercising the said constitutional power, which is meant to ensure a fair and just investigation. So, constitutional courts are envisaged with the power to order fresh de novo or reinvestigation, even after the commencement of a trial and examination of some witnesses, because of to ensure a fair and just investigation. This is held Dharampal case. In the same way, in another judgment, 2013, Bharati Tamang versus Union of India and others case, 2013, in case of deficient unsatisfactory investigation, it is the duty of the courts to ensure effective conduct of prosecution, and the courts have powers to direct reinvestigation in exceptional circumstances in case it warrants due to deficient unsatisfactory investigation. So, basing on these two judgments held that constitutional courts are having power to conduct fresh investigation, reinvestigation or de novo investigation. So what is the basis for this concept is, that is the only thing is article getting fair investigation is fundamental. You see, this is Ananta judgment ratio. So what did he say? Applying the law laid down by this court in the case of Dharampal and Bharati Tamang to do the complete justice and in furtherance of fair investigation and fair trial, the constitutional courts may order further investigation, reinvestigation, de novo investigation, even after the charge sheet is filed and the charges are framed. If the submission on behalf of the accused, and even as observed by the High Court, that once the charge sheet is filed and the charges are framed, there may not be any order for further investigation, reinvestigation, de novo investigation is accepted. In that case, the accused may see to it that the charges are framed to avoid any fair investigation, fair trial. It would lead to travesty of justice. So even after framing the charges or filing the charge sheet, constitutional courts are power to direct fresh inquiry, fair inquiry. So, as told earlier, if police investigating agencies removed some of the persons despite the victim repeatedly held that he is the responsible for the offense, or removed some serious offenses and adding later offenses, all these lacunas can be removed by a High Court by directing further investigation. The reason behind it is, as observed and held by this court in the aforesaid para number 12.3 decisions, the victim has a fundamental right of fair investigation and fair trial. So this is the concept behind this. So victim is having fundamental right to get fair investigation by the police. So police acted maliciously and they did not conduct, they are not proceeding the investigation in fair manner, then the victim can approach High Court or Supreme Court basing on the matter and can get fair investigation. Now come to Telugu. పోలీసులు విక్టిమ్ బాధితుడు ఇచ్చినటువంటి ఎఫ్ఐఆర్లో ఉన్నటువంటి కొన్ని తీవ్రమైనటువంటి నేరాలు వచ్చేటట్లు జరిగినట్లు బాధితుడు చెప్పినప్పటికీ కూడా పోలీసులు సపోజ్ హత్యాయత్నం కేసు రావాల్సింది 324 323 సెక్షన్ పెట్టేసి ఐపీసీలో ఏదో చిన్నగా గాయపరిచినట్టు చెప్పారనుకోండి, అంటే మన బాధితుడు ఇచ్చిన ఫిర్యాదులో నన్ను హత్య చేయడానికి ప్రయత్నించాడు, గొడవలు పెట్టి కొట్టాడు, నరికడానికి ప్రయత్నం చేశాడు, లేకపోతే చంపాలని తీవ్రంగా ప్రయత్నం చేశాడు, ఉద్దేశపూర్వకంగా ఒక మారణాయుధంతో ప్రయత్నం చేశాడని ఇచ్చినప్పటికీ ఆ 307 తీసేసి ఇంకోటి పెట్టడము, లేకపోతే ఒక మినిస్టర్ ఈ కేసులో ఇంతకు సుప్రీంకోర్టు అనంత కేసులో ఒక మినిస్టర్ని క్యాబినెట్ సిట్టింగ్ మినిస్టర్ పేరు చెప్పినప్పటికీ కంప్లైంట్లో ఇన్ఫర్మేషన్లో ఆ ఎఫ్ఐఆర్లో తీసేయటాన్ని, ఎఫ్ఐఆర్లో పెట్టకపోవటాన్ని ప్రశ్నిస్తూ ఆ కేసు వేయటం జరిగింది. కాబట్టి ఆ విధంగా పోలీసులు చేసే తప్పుల్ని, అంటే ఫెయిర్ ఇన్వెస్టిగేషన్ చేయకపోతే ఆ ఫెయిర్ ఇన్వెస్టిగేషన్ పొందే హక్కు ఈ బాధితుడికి ఉంది. అది ఫండమెంటల్ రైట్. అది ఆర్టికల్ 14, 21 అండ్ 39A భాగం అని చెప్తూ రాజ్యాంగపర సంస్థలు అనేటువంటి కాన్స్టిట్యూషనల్ కోర్టు అనేటువంటి హైకోర్టు, సుప్రీంకోర్టుకి ఫెయిర్ ఇన్వెస్టిగేషను, డీనోవా ఇన్వెస్టిగేషను, ఫ్రెష్ ఇన్వెస్టిగేషను కండక్ట్ చేయమని చెప్పి పోలీసులకి, స్టేట్ ఏజెన్సీస్కి డైరెక్షన్ ఇచ్చే అధికారం ఈ కాన్స్టిట్యూషనల్ కోర్టుకు ఉంది. ఆ అధికారం పోలీసులు ఛార్జ్షీట్ వేసినప్పటికీ, మ్యాజిస్ట్రేట్ కోర్టులు లేదా సెషన్స్ కోర్టులు ఛార్జెస్ ఫ్రేమ్ చేసినప్పటికీ కూడా రాజ్యాంగపరమైనటువంటి ఈ కోర్టులకి, కాన్స్టిట్యూషనల్ కోర్ట్స్కి అధికారం ఉన్నది అని చెప్పి ఈ కేసులో చెప్పడం జరిగింది.